Welcome, welcome. I am the loud little ducky. This is Owens v. Echard. Response to lunch motion. One does not simply go to lunch. This is going to be a long one, so buckle in and let's go. So the Superior Court of the State of Arizona in and for the County of Maricopa filed on April 10th, 2024. Response/objection to petitioner's motion to compel lunch and for alternative relief assigned to the Honorable Judge Matta. Respondent Clayton Echard, by and through counsel, undersigned, hereby objects and responds to petitioner's motion to compel lunch and for alternative relief filed April 8, 2024. As and for his response, respondent states as follows. Maybe this was meant as a joke. But in the context of other communications from petitioner, bar complaints, more threats of bar complaints, threats of lawsuits, hinting at lawsuits against journalists, and allegations of it is inappropriate. Parenthetically, the case law cited by petitioner is factually distant from this matter, where petitioner continues to evade compliance with basic disclosure. To be clear, respondent does not object to the motion of lunch with petitioner's counsel. However, as repeatedly expressed to petitioner, see below, respondent will not engage in lunch without the compelled disclosure and in the light of the nature of petitioner's communications without a neutral third party present. As detailed in an email to petitioner's counsel, there's communication. On April 1st, 2024, as for lunch, I enjoy food. In my 24 years of practice, I have never said no to a lunch or a beer invitation. But I'm saying not now. Perhaps this will be nothing more than fodder for a future blog post, but I trust you're being sincere. Your statements and emails over the phone, on your blog, on your Twitter, etc. may have been the product of passion, but they were received as combative and unpleasant. Given your verbiage and your approach online, and to my team, I think Judge Matta will side with me on any trepidation issues here. That said, I am quick to forgive, and if your email is meant to be an olive branch apology for professional allegations and overzealous advocacy, I would certainly accept that apology. So he wants an apology for Gingras' behavior. Doubt he will apologize. I don't even know if he knows how to say sorry for real. As further provided to petitioner's counsel on 4/4/24, while I appreciate your right to speak on all issues, I am deeply uncomfortable with the tone you are using in emails to my office, on Twitter, and in your blog. Comments like, I am the Conor McGregor of litigation, and I look forward to reading their obituaries, really invoke something extremely unpleasant. Using the term special ed in a derogatory way is also not something I am comfortable with, either as a lawyer and a parent. Yeah, nobody's okay with that. I have never tweeted in my life. There are certainly passionate followers of this case from Bachelor Nation, due to your client bringing the matter to the world's attention. That said, I was forwarded some of the postings over the past few days, as well as your recent blog post, and I am just not sure why you are engaging with them. We don't. I am also not certain why you are publishing court documents and your client's personal medical records contrary to the court order. That is the second time in a filing to Gingras that Woodnick has reminded him there is a court order against sharing medical records right now, because she likes to blame them on Clayton. When it's her, it's always her. Number 1. Lunch does not fix the fact the petitioner has failed to provide disclosure notwithstanding the granted motion to compel. These antics have delayed. They have delayed work of both medical and forensic expert reports, footnote 1, as detailed in an email to petitioner on March 29th, 2024, giving us the picture and timestamp for our forensic technology expert, Brian Neumeister, the Johnny Depp god of pictures. When there's already admissions of records fraud, and a trial in 2 months is also not something that requires delay. And as we said before, we will address the photo if it is complemented by the alleged verifiable metadata and medical record. Blank claimed she deleted the picture from her iPhone. Claimed sister deleted it too, but also claimed she sent it to the telemed provider. There should be a very clear digital footprint for Neumeister, and a picture is not going to cut it in light of the history and her testimony. We also are awaiting the original sonogram she claims she got anonymously from Planned Parenthood, which has affirmed it does not offer anonymous appointments and that it is an easy accessible patient portal. This was the sonogram she admitted she doctored, and that is the core of our motion for relief under the Order of Protection Cause number. The Planned Parenthood, to get the original sonogram, if she got one, is they are going to have to go back to the dates of Michael Maraschini, in my opinion. Since I don't know about the 2014 case, maybe it came from there. If so, they've requested those records. But California case, pregnancy, went to Planned Parenthood, supposedly. She did not go to California Planned Parenthood here, even though that's what it states on the documents. I think it ties back to 2016 and that case then. Let's move on. As experts are waiting for the alleged twin fetus pictures, records between petitioner and blank on the date of the alleged miscarriage, and the alleged records from the telehealth doctor that allegedly treated petitioner for her alleged miscarriage. These records were specifically confirmed to be in the possession of petitioner's counsel when he stated, "Gregg, that's not going to be a problem. You're going to love those image dates," because the images are dated July 23rd, 2023. July? Petitioner testified in 2 related protective order hearings, at her deposition in March, and made statements before this court that grossly differ on the timeline for the alleged miscarriage, also known as perjury. All right, let's read this footnote 2 here. When you speak with redacted and redacted, they will confirm fabricated documents and fake pregnancy allegations were happening back in 2014. And since you saw she blamed Greg Gillespie for the other ultrasounds that came from her email address, phone number, and the emails and texts as will be verified by Neumeister, she should be reminded that she did not even know Greg existed back in 2014 when she first claimed to be fake pregnant by redacted, and the records are faked. Now we're going to go over to the footnote 2 over here on page 4 that says petitioner also presented evidence in these proceedings that include alleged videos of her pregnant stomach and statements by her neurologist that she looked 21 weeks pregnant. If petitioner is now claiming she miscarried in July, she would not have had a visible growing pregnant stomach that looked 21 weeks. She cannot keep her lies straight. She's not used to getting caught. She is caught. And now, not only one person, Clayton, is being uncovered, but Lies going back to 2014 are being uncovered. 10 years worth of lies is coming out. I can see why Owens is freaked out, panicked, head is spinning, she doesn't know what happened when, and blah, blah, blah. She's getting her cases mixed up. Because this is what happens. When you tell the truth, you don't have to remember all this stuff. It's like, oh yeah, here's the proof. Like, so simple. She has made this so complicated. Nobody else, just Owens. Woodnick goes on to say, perhaps in addition to trying to cajole a trial continuance, the missing disclosure has not been provided because it contains more fabricated records. Instead of acknowledging that she lied to this court, petitioner has ostensibly dialed up her photoshopping skills, and she insisted on deposing Echard in February, video recorded, and allowed her series of since-withdrawn attorneys, Bonnie Platter, Alexis Linvall, and Corey Keith, to unwittingly use a sonographic exhibit that she since has admitted to doctoring. This is the same fake sonogram she flaunted, claiming she was pregnant with Echards twins after showing up to court before Judges Duty and Judge G with ostensibly fake pregnant stomach, claiming she was 100% pregnant and due with twins on February 14, 2024. This is not just a fake sonogram that was used in court proceedings, but petitioner testified the collateral protective order proceedings that her OBGYNs were Dr. McCool and that she was seen last Friday by Dr. Higley. There are no records that support these statements by petitioner, and the provider's absence of record confirmed they never treated petitioner for pregnancy. Now, contrary to the confounding responses to this court's direct question, at the last status conference and her own medical records, her public postings seem to range to claim her alleged miscarriage either took place in July or is even as late as November 2023. See email from petitioner's counsel dated 4/8/2024 in Exhibit 1. We are going to go through all the exhibits. It's part of what takes so long is because there's so much. Because Gingras has continued to just blah, 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 blah. That's all he does. He's got so much free time. I don't know where he finds it. I wish I had as much free time as Gingras did. While the petitioner appears to have recently toned down her social media posts, her newest counsel has backfilled that void with persistent Twitter and blog posts and outlines his theories of the case, including his anticipated motions and more. See general postings by petitioner's counsel, Exhibit 2, a sample of these postings below. So we will look at these in a bigger format later. This is not complicated. Petitioner claims she has the bulk of the requested disclosures in her possession. Contrary to her testimony and statements to this court through her parade of prior attorneys, petitioner has stated several times that she has the requested information. See petitioner's counsel's Twitter, and the other one is taken from the petitioner's counsel's blog. Is his footnotes. And she now ostensibly claims to have miscarried in July. Specifically, petitioner, through counsel, stated in emails that he had photos of the fetuses, the contact information for the telehealth provider, and the communication between petitioner and her sister, all of which is requested in the respondent's motion to compel. See General Exhibit 1. All right, and then we've got 3/27/24, 9:53 a.m. Let me speak with blank about the request for the photo of the sacs. Hate that word. This is like Gingras. Like, hate that word, sacs. Okay, 12-year-old. Jesus. Like, why can't it be like a sack of potatoes? Sacs. That's what they're called. grow the hell up. She told me she had this photo available, and if she does, then I immediately will provide it to you today. Same with the name of the telehealth provider. Emphasis added. We're still going to do that. 3/27/24 at 1:54 p.m. Having said all that, I just got off the phone with blank, and she is sending me the SAC photo and the name of the telehealth person. Emphasis added. Emphasis is always added. 'Cause drama and sparkles and show. 3/28/24 at 5:20 p.m. As promised, I have talked to Blank about the fetal sac photos, and she has produced copies of the photos to me. I have them in my possession right now. I am prepared to disclose these to you, along with some additional information Blank found, additionally information showing a consult with a healthcare provider at the time the fetal sacs were discharged, or whenever you call it, or whatever you call it. Okay. Emphasis added. 4/8/24 at 3:07 p.m. As I mentioned before, I have the photos you wanted to see. I understand you want to give them to your experts. Gregg, that is not going to be a problem. You're going to love the images, dates, because the images are dated July 23rd. I also have the text messages between Blank and her sister dated July 23rd, 2023. I do have some telehealth information showing Blank seeking medical advice on July 23rd, 2023. Seeking or got? Did she just ask and she got no response? Because seeking, like, we're seeking the truth, but yet Owens has not responded with truth. So seeking medical advice and getting medical advice are very different. Which I think is something maybe Gingras is going to argue. Well, see, she wrote a telehealth doctor trying to get answers, but she said that they told her this and this, and no, you don't need to go to the hospital or anything. Yeah, it's nothing to worry about. Not that big of a deal. It is that big of a deal, especially if nobody responded. I don't think that is helpful to either party, but it is something I am willing to disclose. Why is it not helpful to either party? It is very helpful. Because if she didn't get medical advice that she said she got, she's lying. It's not helpful to you, but it's helpful to Clayton. Underlines in original, emphasis added. Footnote 5. Notably, if the photos were from July 23rd, as current counsel is now claiming, but not disclosing, then every filing under the date is per se a violation of Rule 26, and the testimony at the deposition and the protective order proceedings were all perjurious. Yeah, because she filed in August. Instead of just simply complying with Rule 49 and disclosing the information he acknowledges having, counsel bombards respondent's attorney and his attorney's office. Yeah, we don't need you saying, oh, look what we got. Look what we got, Gregg. Look what we got. Dangling the carrot in his face. Send the stuff over as the judge told you to do. We don't need you to say, oh, got it, unless you're saying, got it, here it is. Like we've met the judge's requirements. No, but he just wants to be a child and be like, we got it. But we're not going to give it to you yet. But you're going to love it. You're going to love what we have. He just makes me sigh. He's bombarding his staff with communications, comments about personal sanctions against attorneys, and suggestions that the state bar needs to be involved. I think they do need to be involved. Not for Woodnick, but for Gingras. He is not performing ethically, professionally, nothing. And he says he has Laura's permission, written permission, to behave in this manner and do these things. And if she continues to have poor judgment on things. But if she didn't, she should be pissed off. I can understand her not firing him because it's getting harder and harder to find an attorney that will be on this case. So I can understand keeping him, but surely she's pissed off about this stuff because this has made things worse for her. So I think the state bar does need to be involved. It's just with the other party, the one who hasn't had any bar complaints filed on him by opposing counsel. Petitioner, having already filed 2 complaints dismissed and at least 2 against others, her prior attorneys also dismissed, and so on. See Generally Exhibit 1. On April 3rd, 2024, at 11:20 a.m. Jesus, man, seriously? I mean, seriously. Does Clayton mean that much to you? So look, I guess what is going to happen next is you can submit your proposed order on the MTC to the court. I will respond and object to the order, and I will probably have to file a motion asking for relief on the basis of fraud by you. This stuff is going to be messy, like really messy. It's already messy. It's already been really messy, way before you got here. But thank you for agreeing. If you won't agree to do something remedial, I need to be clear about what's happening next. I am going to file something explaining this crap to the judge, and I am going to ask her to make a referral to the state bar, and that applies to both you and Isabel. Isabel now knows that you have lied to the court multiple times. She cannot sit back and allow this to continue. I don't care if she's new. I don't care if she hasn't signed any pleadings. That is irrelevant. Isabel cannot stick her head in the sand. She has an absolute duty under ER 8.3 to report professional misconduct, as do I. Somebody report him for misconduct, please. If we all have a duty and we can't stick our heads in the sand, report him. Report Gringas. She also has an absolute right under ER 8.4a not to help you violate the rules. Who said she was helping him violate rules? Nobody. If Isabella sits back and lets this go further off the rails without taking appropriate remedial steps, she is putting her own license in peril. 4/4/24. As a compromise, I offered this proposal. Don't apply for fees right now. In return, you might not seeking fees right now. I will agree not to bring a motion asking for relief from the MTC order on the basis of fraud. Like I said, I am not happy about what I have recently learned, but if we can avoid fighting over that new issue now, it would be helpful for both sides. Threatening, he likes to make threats, just like his client. I'm telling you, they are 2 peas in a pod. Number 3, petitioner's motion is also misleading. The parties are communicating over email, and the respondent is responding where appropriate. Undersigned has no ethical or legal obligation to expose himself to unnecessary criticism. That is not conducive to a resolution. Yeah, we don't have to respond to rude-ass people. While petitioner's counsel did eventually apologize for his toxic comments, the online activity continues, and the toothpaste is out of the tube. Can't put that toothpaste back in. Have y'all tried? Like, legitimately tried? I made my kids try to put the toothpaste back in. It didn't work very well, but it proved a point. Undersigned counsel realizes that filing the objection and bringing the above mentioned to the attention of the court will likely escalate petitioner's tactics. but believes it is relevant for the court to have all information when considering petitioner's motion to compel lunch and alternative relief. Number 6, this is not a complicated case. Contrary to what petitioner promotes, trial already continued once due to some lack of disclosure. Is in June, and respondent is prepared to proceed and argue appropriate inferences consistent with the data set and the lack thereof, and the court can enter relief as deemed appropriate. Number 7, respondent is entitled to reasonable attorney cost and fees in the responding to this motion pursuant to ARS 25-324. Petitioner has been forced to incur significant fees due to respondent's continued efforts to avoid resolving her perjurious statements in these proceedings that have affected at least 3 cases in Arizona, not including those involving other presumable victims in Arizona 2 and in California 1. Quite simply, there is nothing to be resolved without the disclosure respondent has already spent significant time since at least October 2023 attempting to gain access to, which have repeatedly been met with petitioners' overt efforts to avoid the same. Likewise, intimidation does not resolve this. Attorney's fees and accountability do. Yeah, both of them need to be held accountable. Wherefore, respondent respectfully requests the court A. to deny the petitioner's motion for lunch, B. grant the respondent leave to file a China doll affidavit for his reasonable attorney fees and costs under ARS 25-324, C. enter appropriate sanctions and other relief as the court deemed proper. I think Woodnick should get all the things he wants in this petition or motion. Respectfully submitted the 10th day of April, signed by Woodnick, and copy to the court and other people needed. All right, here we have an email from Friday, March 29th, 2024, and it says, David, I did hear Lexi moved to Texas with her husband, also a lawyer and a great guy who clerked for me many moons ago. Billy T will know what is going on at the office if you're getting a bounce back from the Lexi's email address. I can't imagine that she was not given her file, given Owens filed a bar complaint against her. It was investigated and dismissed. She also has recently filed for a protective order. I was endorsed by the bar because I got a complaint at the same time as Lexi. 2, Corey went out on his own during this short tenure. He responds quickly, but his paralegal is wonderful and super on top of things, so you might want to copy her if you are emailing. Isabel Sissel. I am glad you were able to get a hold of him. Yes, both Isabels in this case are wonderful. Okay? Corey was great. He was doing the best with what he had. He was trying to argue what he thought was true, and then seemingly as soon as he found out it wasn't, he was out. We object to any extension. It is not you. You are just the umpteenth attorney and the umpteenth who thinks they can get this resolved only to be fired or need to withdraw for ethical reasons. Number 3, we object to any extension. I already read that. I appreciate and I'm really respecting your cautious approach not to step in dog shit. But disclosing the date of the alleged miscarriage is not something that requires Owens getting a continuance, and we will object to the same. Giving us the picture and the timestamp for our forensic technologist expert Brian Neumeister when there is already admissions of record fraud and a trial in 2 months is also not something that requires a delay. And as we said before, we will address the photo if it is complemented by the alleged verifiable metadata and the medical record. Owens claims she deleted the picture from her iPhone, claimed sister deleted too, but she also claimed she sent to the telemed provider. There should be a very clear digital footprint for Neumeister and a picture of the sonogram she claims she got anonymously from Planned Parenthood, which is affirmed they do not offer anonymous appointments and that it has an easily accessible patient portal. This was the sonogram she admitted she doctored, and that is the core of our motion relief under the order of protection cause number. He put that in his response motion. There is already an order about the medical records. We have been through this with her failed motions and whatnot. We need that picture to give us Dr. Dean's and Justica line. Again, we are not interested in a picture of a picture. That is where the arts and crafts issues come in, and notwithstanding blank invoked Rule 2. When you speak with blank and blank, they will confirm the fabricated documents and the fake ultrasounds that came from her email and phone number in emails and texts, as will be verified by Newmaster. She should be reminded that she did not even know Gregg existed back in 2014 when she first claimed to be pregnant by blank, and the records were faked. Our paralegal Mary Beth will be sending you deposition exhibits under a separate cover. Number 6, again, this has nothing to do with you. We have been involved in litigation with Owens since 2021, in this case / collateral proceedings since October. And her claims and delay tactics are exhausting. Indeed, Woodnick, indeed. Gregg and Isabel. March 28th, 2024. And it says, quick follow-up on a few things. 1, per the attached email, I just learned that Owen's first attorney, Alexis Linvall, is no longer with the modern law firm. Unfortunately, her Arizona bar record still shows her working there, but apparently her LinkedIn has been updated to show that she has left Arizona and moved back to Texas. Yuck. F you. Gingras. Texas is a wonderful place. It is a great place. Maybe not to people like you, though. You can stay away. We don't want you here. Based on this, it sounds like getting a copy of the file from Alexis may be a challenge. As you will note, her firm claims that a copy of the file was given to Owens, but Owens says this isn't true. Gee, I wonder who's telling the truth. Known liar or attorney? To be like, here's your stuff, I'm out, bye. Move to get away from this crazy lady might be what she did. In any case, that issue will need to be resolved one way or another. After not hearing back from Corey, I gave him a call this afternoon, and fortunately I was able to reach him. I didn't realize he had also changed firms, apparently in the middle of the case. Per notice he filed. Yep, Corey did change law firms in the middle of the case. Corey said he's going to need more time to finish gathering Owen's file, but he promised to get this to me ASAP. 3, since I don't have the information I need yet, I am going to file a motion asking the court for more time to respond to the motion to compel. Nope, not happening. Denied. If you want to let me know your position, I am happy to include a line that says I've consulted with you and you do or do not oppose the request. It's so clearly appropriate to ask for more time. I know the court is going to grant the request whether it's opposed or not, but just let me know your position so I can include that in the motion. Oh, you knew the court was going to grant it? Oh, you were wrong. Imagine that. Gingras has been proved wrong already. As promised, I have talked to Owens about the fetal sac photos, and she has produced copies of the photos to me. I have them in my possession right now. See, here's the dangling carrot. I have them. I have them. I'm prepared to disclose those to you, along with some additional information. Owen found additional information showing a consult with a healthcare provider at the time the fetal sacs were discharged, or whatever you call it. Okay, great. But Owens is concerned about the photos being publicly released, and she asked me to request that you agree to a protective order as to them. You, Gingras, and Owens are the only ones sharing this nonsense. You're the one putting the medical information out there to the public. So don't worry about Woodnick and Clayton sharing the info. Worry about your client and her Dropbox links. Note, I have spent several hours today reading through all the pleadings on the docket, and I see there was a prior motion for a protective order which you opposed and which the court denied. Obviously wasn't involved with that, but my guess is that the motion was denied because it was simply too broad or non-specific. Here I am just asking for you to agree not to publicly disclose photos showing bloody tissue, at least until trial. This is a very narrow request, so I don't think there's a good reason to oppose it. Nevertheless, please let me know your position. He's not going to disclose it because there's a court order, and Woodnick follows the court orders. I finished reading Owens' entire depo, which was extremely helpful. But you said if you found out she was lying, then you would leave the case. The deposition has her admitting to lying and forgery, falsifying, fraud, all that, and you're still here. Joy for us. But the copy of the transcript provided by Isabel did not include any of the exhibits. I can see on the record that Corey ordered a complete transcript, so maybe I will get that once he hands over the file. But in the meantime, if you have a copy of the exhibits, hopefully numbered according to the transcript, that would be super helpful. Thanks, and more updates will follow shortly, I'm sure. And then it shows that on her LinkedIn profile, Linval is in Texas. Oh, she's in Plano. That's not too far from me. Thursday, March 28, 2024. Corey and Alexis, it's been over 24 hours and I have not received a response from either of you to my message below. It's Easter weekend. I'm sorry you joined the case on Easter weekend. It's not a great time to be trying to contact people. I get you are short on time because you just got here and you need to catch up on everything. But it's Easter weekend. It's Good Friday. Well, Thursday's not, but Good Friday is on Friday, obviously. I am sorry to be a pest, but as you know, Mr. Echard's counsel has filed a motion to compel in which he argues that discovery was not previously provided by petitioner. He also claims that he tried to meet and confer with current counsel, which I think was reference to Corey, but that he did not receive any response to those efforts. The response to the MTC is currently due Monday, April 1st. And in the order to fully respond to the motion, I need to receive copies of Owens' files. Okay, so I see why he's trying to get to everybody by on this Easter weekend. It sucks. But I get why he's trying to rush it. Because I have not received them from you, I'm probably going to file a request for an extension of time, but that still does not make this any less urgent. Please respond to me by the close of business today to at least acknowledge receipt of this email, and please let me know when I can expect to receive the case files from you. I will also follow up by phone with both of you later today. Thank you, Esquire. Ask your client how to track emails and if they've been opened and seen or not. She knows all about the mail tracker. Okay, so this one was sent the day before that one, Wednesday, March 27th, 2024. Corey and Alexis, I just have been retained to represent Owens in the paternity matter involving Clayton Echard. I am CCing Mr. Echard's counsel on this message just to keep Gregg and Isabel informed of my process. A conformed copy of notice of appearance is attached. Because I have only been involved in this matter for a few days, I'm still getting caught up. As part of that effort, I need to request copies of Owens' file from both of your offices. I have access to all the pleadings on ECR, so please do not send any of those. Instead, I'm mainly looking for two things. Copies of all case-related correspondence and copies of any Rule 49 disclosure documents, which presumably would have been sent to Mr. Echard's counsel and thus may already be covered by the first part of my request. Ideally, if you use Outlook, I prefer to just have case-related emails exported to a single PST file. If you are not using Outlook, I'll just take the emails in whatever form is easiest for you to produce. How about you just take them as you get them? Period, end story. We don't care how you like it. It's not their problem anymore. If you need me to send you a link to an online folder because the files are too large to send, please let me know and I'll send you a link privately. Obviously, Gregg and Isabella shouldn't receive copies of any privileged communications. Thanks, and let me know if you have any questions or need anything else. Esquire. Sorry if things keep jumping around. I keep hitting my mouse on stuff. Mary Beth Burrows. Wednesday, March 27, 2024. CC'd Mary Beth Burrows and Isabel Rainey sent to Gregg Woodnick. Gregg, let me speak to blank about the request for the photo of the sacks. Hate that word. She told me she had this photo available, and if she does, I'll immediately provide it to you today. Same with the number of telehealth provider. And just to be clear, while I don't mind expediting these issues, it's obviously needed, I really don't intend to commit to a quid pro quo as far as getting to you to agree to an extension of time to respond to the motion. I don't think it's appropriate at this stage. Well, you like to do them in any other form, so why not here? If it was absolutely essential, I could easily respond to the motion by Monday, but that isn't the point. The point that I don't want to file something that isn't helpful to the court because I haven't had enough time to gather information needed to provide a comprehensive explanation of our position. Also, I don't think, based on what I've seen so far, that a sufficient good faith pre-filing effort was made to resolve the discovery disputes, which may not have even been real disputes. That is probably the fault of blank prior counsel. Don't you go blaming Keith. Assuming they didn't respond to you. But since I don't have blank files yet, I am not in a position to know if that's the case. As you saw by a separate email a few minutes ago, I just reached out to Owens' prior counsel to ask for her file. Hopefully I will have this information later today. For now, as it relates to the motion to compel, I am just not in a position to even explain my side to the judge unless and until we go through the process of talking about these issues in detail, which is what I'm trying to do right now. So here's my plan. I don't want to make a big deal regarding the motion. Instead, I'm going to do everything I can over the next few days to dig into the issues raised by your motion and either resolve them by giving you what you're asking for. No, you're going to be giving him those things that he's been asking for because the judge told you you are going to give him those things. Or by investigating the issues sufficiently so I can explain our position to the judge. I don't accept half-assed, incomplete stories, so I have no intention of giving one to the judge. Well, you're not following orders. The order is hand over your information. Disclose your exhibits. This is discovery. Give it all over. Stop doing that half-assed. Since the current response date is Monday, my plan is to either fully resolve the issue before then, or if it isn't possible, at least I will be in a position to explain to the judge what's going on and why the motion is either moot or without merit or just ultimately premature because there wasn't enough effort made to resolve the issue. I can't tell the judge what our side is until I complete my investigation into the issues. In other words, let's just keep pushing forward for now, and then let's see where things stand on Monday. Esquire. You need to get the discovery. And Woodnick has asked over and over and over and over for the discovery. So saying that there wasn't a good faith effort made to try to obtain this discovery is just bullshit. It's a bold-faced lie. We know how many times Clayton has asked for the discovery. Now we don't know who it's to. Oh, it's to David. So Gingras, this is to Gingras from Woodnick. It says, David, we really appreciate your willingness to take this case so far along into litigation. I also appreciate you wanting to focus on a resolution. Having spent Clayton's legal fees having to this exact conversation with a parade of prior attorneys with similar good intentions, please understand it. We are a bit jaded. Multiple prior lawyers unwittingly presented records to the court that were fabricated by Owens. These records not only were medical but also included fake letters from law firms. It is really unbelievable. Put bluntly, Owens has misused court proceedings in multiple states and perpetuate the most bizarre of cons for relationships. She is either seriously mentally ill or diabolical. 4. Very established men have documented her faking pregnancies, demanding relationship contracts for abortions, and fabricating medical records. You might want to call blank's attorney in California. While the media seems to think my office orchestrated fake pregnancies and suicide threats back in 2014, blank who first dealt with. We are looking for a finding that the filing and subsequent filings are malignant due to Rule 26, etc. We get that blank may be judgment-proof, as prior attorneys have discussed, but of course that is not the legal standard, and Clayton's ability to collect a fees judgment is not really our focus. Clayton is entitled to the court's findings that Judge Maddow will make in the 3 matters now in her lap: paternity, order of protection, and the injunction against harassment. The value of judgment may only be on paper, but TEDx, Medium, and Reddit need to be recategorized as fiction because she will, the minute you are out of the case, or sooner, as she did with Corey, start spinning more yarn, emailing the media, and sabotaging more of Clayton's professional endorsements with her nonsense. Note, there is currently an investigation regarding Owens pretending to be a Black Howard University reporter who does not exist, Chase J. Jones, and the distributing an article in the middle of the case attempting to cancel Clayton, claiming he was involved with the misuse or the use of the N-word. Contrary to Owens' beliefs, we do not control the media circus she started. But if Owens wants the reporters to run out of material, she needs to stop feeding it to them. She should go to whatever DBT inpatient program can help her stop living a perpetual con. She needs to admit to the fraud, dismiss the protective orders against Clayton, Michael, and Gregg, and have you help her write a public apology. I am not a cast member, but she would also do herself a world of favor if she included in her apology the malignant R allegations about both Gregg and myself, and now Echard, that she made to Judge Bacchus in her public apology. Yep. She also made R-ing allegations to Michael Maraschini, too. Sounds like everybody has R-ing, and the only person R-ing here is Owens. She's just raking them across the coals, just putting people more in debt, just flat screwing them over. That said, we know the Title 25 court only can do so much here, and the paragraph above is a pie in the sky. Still, Clayton is exhausted emotionally and financially, but he is fully committed to this litigation until we get a judgment that he can show the world. So, motion to compel. We agree there is an obligation to avoid discovery issues. We did that long before you were on board, and filing the MTC was already a last resort. Clayton is not willing to withdraw at this time because we are 10 months in. Owens faked medical records, and we have a trial date. We also have our experts who need whatever other records Owen claims she has, but with proper verifiable chain of custody, given her propensity to cut and paste. Arts and crafts. We would consider a brief extension for a response as a professional courtesy to you, as this is not your fault, but with some contingencies. An extension would require Owens to immediately provide the picture she now suddenly claims she has of the fetuses that she testified she deleted and did not have her iPhone anymore, and her sister deleted them. That information should be provided today from you. It will be time and date stamped and will put an end to the great mystery of when the alleged miscarriage happened. Remember, she stated in court that she did not know. She stated in her deposition the same. So how wonderful it will be to know the date stamp on an image that will be in her medical records from the telehealth doctor she sent the image to. Yes, it will be so nice to have all these things align and make sense for once. I don't think that's actually going to happen because, well, look who we're dealing with. We are eager to read the records from the doctor who told her not to worry about a miscarrying 20-week twin fetuses, which would have actually be a fetal death, warranting a death certificate under law. But see, that's the thing. If she miscarried in July and she talked to the telehealth doctor in July, then she wouldn't have been miscarrying 20-week fetuses. And so the doctor maybe was like, no, you don't need to go to the hospital. But it also, if that is true, all the July stuff, that makes everything else not true, and she lied and perjured herself. Because there were no babies the entirety of this case from August till now. So either way, she's screwed and fucked up. Sorry for my language. She must also immediately provide the name of the telehealth provider so we can obtain the records directly from them, which should be included the photo per her sworn testimony. Owens knows there are no medical records to support her fake pregnancy narrative, as confirmed by my 7+ providers who have no records of ever seeing her, notwithstanding her deposition and testimony in 2 protective order proceedings. I trust you have reviewed the records from Planned Parenthood, Dr. McCool's office, and Dr. Higley, where they confirm that your client was never a patient there. We will issue another HIPAA records request for the Banner records, but expect them to be similarly lacking in evidential value. We appreciate you have a lot to sift through, and you are getting a brief extension is reasonable, but we need the telemed provider and the picture that now has magically appeared contrary to her testimony today. Once we receive these, we can discuss the length of an extension is reasonable and further discuss resolution options. Again, please do not take it our instance here personally. You may withdraw or be fired before the ink dries here, and we need to move this forward. If it resolves sooner, that would be wonderful and welcomed. Gregg and Isabel. And then let's see, based on this, a challenge. He changed firms. Feels like photo. Publicly released several hours reading through the... Okay, so we've read all of that, the second page here. So we don't need to reread that. And then this first page is just another document that we've already read through that was attached to the last one. But here on the second document on the screen, David, I appreciate that your effort to exorcise blank from this mess she caused, but we strongly disagree with your analysis of Rule 26, which is legally distinct from Rule 11 in several important ways. If Owens thinks this will stop her exposure to sanctions, then we welcome your motion to strike and will respond accordingly. That said, I am more than happy to coordinate a meeting and confer with you, but it will have to be tomorrow as I am in mediation with blank today. I sat on the Supreme Court Rules Committee appointed by Justice Bates, or Bells, ink is messed up there, and specifically was on the subcommittee that addressed Rule 26. I am confident that there are myriad legal and factual issues here, and we will not be withdrawing any of our motions as sanctions are more than warranted. Well, they ended up doing it, but at this point he wasn't going to, but they maybe thought and talked about it. Without diving too deep into the issue, here are a couple of quick comments. Owens had noticed, if you only look at motion to leave to amend, it contains detailed allegations about Rule 26 on pages 5 and 6 of the amended answer. The motion for sanctions was not filed until January 3rd. So she was given written notice on the specific Rule 26 allegations more than 10 days before filing the motion for leave to amend. There is also several emails and communications with blank parade of prior attorneys that met the same. Owens would not have been able to withdraw her petition. Dismissing the entire petition after a response has been filed requires either agreement of both parties or approval of the court after a motion to dismiss. She filed a motion to dismiss before the court motion for sanctions, which the court denied, and expressly preserved the claims for attorney's fees and sanctions. This is consistent with Rule 46A 1B. Court may dismiss a petition on such terms and conditions as the court deems proper, including the resolution of any claims by the responding party. We can talk more about this over the phone, but I will save the full legal analysis, including response to the reference Rule 11 case law, which is neither directly on point nor analogous to Rule 26, which is intertwined with Title 25 actions and the legal distinguishable. I will also briefly point out that Rule 26 permits the judge to move for sanction on its own upon the finding of bad faith by Owens. I am confident that Judge Matta has all the authority she needs to enter sanctions against Owens based on the numerous filings that she signed that were both woefully improper and predicated on fraud. Owens' efforts would be better spent complying with the uncontroversial rules like Rule 49 disclosure. Our experts are waiting for this miscarriage photos and the simple name of the doctor that she sent images to per her testimony. Brad Newmeister is prepared to examine the images as well. You said you had the information and they are beyond overdue per Rule 49. I trust you saw the discussion between blank Corey and the judge on the issue of the alleged miscarriage in our most recent status conference. Again, this is not about you. You have been nothing but professional, and we appreciate it. No, he has not, but whatever. Maybe this was prior to all that. But we have had these conversations with prior attorneys. We have been in front of the judge. We now have all three proceedings before Judge Matta, or at least the third should be en route after our recent motion. I have also attached the unredacted email to blank's prior attorney in the blank, which Corey was copied on. If you'd still like to meet and confer, I can find time tomorrow. Gregg. So here he's communicating once again. Lies about communication. And then this is just the ending of that email. In the response filed by Alexis, I see she raised the issue properly but only briefly. And in the reply, there is an argument that the requirement of Rule 9 were met and or were impossible to meet. However, the reply is entirely silent about why 10-day notice requirement of Rule 26C 2B was completely ignored. In light of this, I would like to schedule a time to meet and confer with you about this issue per both Rule 9C and Rule 26C 2A. I am available anytime on Monday, so please let me know what time I can call. Here's the problem under Rule 26. If the required 10-day notice had been given, Owens would have had an absolute right to withdraw or appropriately correct the alleged violation, i.e., she would have had an absolute right to withdraw her petition and dismiss the case, subject only to Clayton's right to seek fees under ARS 25-809G, which as of January 3rd, 2024 would have been minimal. That is the outcome required by the rules. But she didn't do that in time. She didn't try to dismiss it within the 10 days. So she failed. Obviously, if Clayton did not comply with the 10-day notice requirement, Rule 26, then he cannot seek or receive sanctions under that rule. That makes sense because by failing to comply with the rule, Clayton deprived Owens of exactly what the rule requires, a safe harbor, which includes a right to withdraw a claim in order to avoid further litigation expenses. Under the circumstances, I need to be clear about my plan. Absent some other explanation, I intend to file a motion to strike your Rule 26 motion based on the apparent failure to comply with that rule. That motion, if filed, would also include a request for sanctions under Rule 26 and fees under ARS 809G for all the fees and costs that Owens has incurred from January 3rd, 2024 to present, and all the fees that Owens continues to incur while this matter remains pending. Well, she shouldn't have brought this matter then, if she didn't want to pay all this. Next time, maybe she won't lie, because her lies are getting more expensive and more expensive with each victim of hers. While I'm happy to give you a more detailed written explanation if you need one, you should construe this email as your 10-day pre-filing notice per Rule 26-2B, because the older version of Rule 11 used to require an actual drafted brief sent to the opposing party. I will probably also do that, just for redundancy, after we talk on Monday. And yes, I understand you may take the position that this issue is either already before the court since Judge Matta set a hearing on the motion for sanctions, notwithstanding Alexis' very brief remark, or that Judge Matta has somehow implied rule on the issue by setting the hearing over objection. If that's your position, we can obviously agree to disagree. I guess it is also possible that I am missing something, i.e., I know you had one or more hearings before Judge Matta since January, and it is possible the issues may have come up and she may have made some sort of verbal ruling, not found in any minute entries that I have seen, in which she determined Rule 26C2B did not apply for some reason. If that is what occurred, I would appreciate whatever details you have about the court's verbal ruling, as this would be subject to revision through alternate means, a motion under Rule 78B. Go to Ninja Schnitzel and you can watch the hearings there if you need them. They're on YouTube. And you can watch the Pawn Scum Posse as well. This is obviously a significant issue given by time this matter reaches trial. The fees incurred by both sides will likely exceed $100,000. It also a clear error of law, which would be an easy matter to reverse on appeal if the judge were to consider a motion for sanctions that was filed in complete disregard for the 10-day notice requirement. Because there is substantial financial value in this issue, and because the law is so clear on this point, I obviously intend to litigate this specific issue as far as necessary, so we need to have a thorough discussion about it, and soon. So please let me know when we can meet and confer about this on Monday. Thanks, Esquire. And all the best from Owens. This is to Woodnick from Gingras. And this is sent on Thursday, April 4th, 2024. It says, Gregg, thank you for the email and your words are noted. I am obviously a passionate person and my words sometimes reflect that. No, you are a douche canoe. You're a jerk, a dick, whatever you want to be called. That does not mean you're passionate. You're just mean for no reason. I do my best to remain professional with you. No, you don't. I am allowed to be upset when I see something that crosses the line. You are the one that has crossed the line. There has been nothing in this case that calls for you acting the way you have. Even if Woodnick had messed up in that filing for sanctions, which he did not, based on what they said, and it was mentioned in a different one, it just wasn't a separate motion by itself, it was mentioned in a different motion that she got. It does not call for you acting this way. So you can be upset, but you cannot act like you've been acting. It's not professional. I don't want to escalate the debate, but as much as you may have concerns about my words, I also have concerns about your conduct. Lying to me or lying to the court are much more serious problems than me tweeting comparisons to an MMA star. That's not all you have tweeted about. But go on. Stop lying to yourself and other people too. But you have asked to tone stuff down, and I agree with that view, so I'm not going to push the issue further at the moment, unless given no choice. So give me another choice. So this was on April 4th. He had many blog posts since then, many tweets since then. He did not tone down anything. As for the other points you mentioned, a few comments. First, I am aware of no order that would stop Owens from publishing her own medical records. Yes, I am aware there is a minute entry order dated 2/21/24 that says, among other things, no party shall disclose outside of themselves, odd wording, any medical or other documentation disclosed between parties. Exactly. But yet you've been doing that. I was obviously not present when that order was entered, so I may not have the full context. Again, go watch Ninda Schnitzel's YouTube. He's got all the hearings. You can go watch them right there. But my reading on this, if Owens discloses medical records to you, you can't share them publicly. And if Clayton shares medical records with us, we can't share them publicly. That's typically, and it is how I read the court's order. If my reading is correct, it does not prohibit Owens from posting her own medical records. There was to be no posting of any medical records because the judge didn't want a bunch of finger pointing, and Owens is the one saying, oh, I don't want the media to know, I don't want the public to know, but yet here she is once again letting the public know. If you would have watched the hearing, you would have known the reasoning for this ruling. And it doesn't matter if you weren't present when that order was entered. You are expected to follow the orders and know them. No oopsie daisies. What she did solely to rebut false claims from your side that no such records existed. He never said that. He said 7+ providers have said there are no records. There is nothing nefarious or improper about this. If you interpret the order to mean that blank is somehow enjoined from publishing her own medical records for the purpose of responding to false statements other people are making, including Dave Neal, who Clayton is clearly working directly with, you need to let me know that immediately so I can take the issue up with the judge. Yeah, and I hope the judge told you, stop posting shit. There is clear case law on that issue. A court could never issue such an order, which is why I give the minute entry order a narrow reading. Well, Owens said it needed to be there. Any broader reading would make the order unconstitutional. In fact, the order would be void. Ab initio meeting, it could simply be ignored. I know this because I've litigated the identical issue in other cases. See examples: Phoenix Newspapers versus Superior Court, holding prior order prohibiting disclosure of details of court hearing violated Arizona Constitution and was void. Superior Court has no authority to foreclose the right of the people and the press from freely discussing and printing the proceedings held in open court. But the disclosure of medical records is not in open court. Those medical records haven't been shared in open court. So I don't know if they fall in line with that. Maybe they do. Owens' medical records were filed in a pleading submitted to the court and which is a public record. There is no protective order against this, nor would there be any basis for one. So anyone is free to share that information with the public, which is all I did. Second, you may not believe this, but I want to make sure that it's clearly explained Owens does not want to fight this battle with you guys. She would strongly prefer to stop all the insanity immediately today. Echard would like that too, but it's going to take your client to stop lying. It's going to take her owning up to all the crap she has done. She wants to fight this battle. Whether you think she does or not, she wants to. Otherwise, she would say, you know what? He's right. I'm so tired of this. I can't spend any more money on it. I've been caught. I just need to surrender. But no, she has dug herself so deep that she has to double down. She has to stick to the story. And she's going to keep sticking to the story till the day she dies. I don't think she'll even admit to it later. She'll say, oh, the judge got it wrong. Now that I have had an entire 10 days to catch up, I see why people like Dave Neal would not want this, because he is making money by exploiting this situation. It's a dream for him. This case has provided Dave with endless content, and when you're a social media guy like Dave, content is literally the same thing as money. It's too bad that he is likely going to lose a lot of money when Owens sues him. But that's a discussion I will have with him separately. Well, good for you. If Clayton wants the public fighting to stop, great. Let's make that happen. Let's resolve this today. Owens is happy to do that, and if we resolve this, I will never post another word about it, and neither will she. The only thing holding us back right now is Clayton. No, it's not. It's y'all's failure to hand over documents. And Owens not telling the truth. That's what's holding us up. But I guess you tell yourself what you need to believe. So Delulu. And then it's going to go into an email that was sent to David prior to this, because this is a response to what we're fixing to go over, I believe. Okay, it says, while I appreciate your right to speak on all issues, I am deeply uncomfortable with the tone you're using in the emails. Conor McGregor. It's unpleasant. Never tweeted about my life. Needs to comply. Okay, we already read that. At the bottom here, it says, Gregg, prepare to be surprised, but for once, I'm not going to be a jerk. I'm going to show you I can be reasonable sometimes. You should be reasonable all the time. Gregg has done nothing to you. Here's the deal. You keep asking to tone things down. Honestly, I do share that view. Do you? Let's see if we can do that. Here's what I'm asking. You submitted an order to the court on the motion to compel, and obviously I'm guessing you plan applying for fees. I don't want you to do that right now because it will cause additional unnecessary work for both sides, and I think we can avoid that just through a very minimal compromise. As a compromise, I offer this proposal. Don't apply for fees right now. If you win at trial, you can ask for all the fees you want, including the motion to compel fees. In fact, you can basically say that the motion to compel ruling entitles you to part of the fees, even without finding or frivolous or whatever under 12-349. So basically, I'm not asking you to give up anything other than your right to seek fees now. You can do that in the 60th days when the case is over. In return for you not seeking fees right now, I will agree not to bring a motion asking for relief from the motion to compel order based on the basis of fraud. Like I said, I'm not happy about what I've recently learned, but if we can avoid fighting over the new issue now, it would be helpful to both sides. Also, in return for you not seeking fees, subject to your right to seek them later, Owens will go ahead and comply with the motion to comply order today. No, she needs to just do it anyways, not if. There's no if. You hand over your disclosures. To be fair, she says most of the stuff you were asking for does not exist, though there is not a huge concession on her part, but at least it's something. So here she's saying she doesn't have everything that he wants. But in other times she's saying she does have all the stuff he wants. Which is it? Bonus points. Ooh, are we in a game? In an effort to be even more reasonable, I will also throw out something else. Because you've already deposed Owens, and because some of what she discloses may raise new questions, what if we were to schedule a conference call with you, me, and Owens, and you could ask some follow-up questions about anything new she gives you? To be clear, Owens hasn't actually authorized me to make that part of the offer. Then you shouldn't be bringing it up. You have to have your client's permission. Anyway, like for offerings and such. Like trial strategy and all that, you don't need their permission. But if you're going to be offering things like deals, you kind of need your client to agree to those things. But she has shown herself to be completely open and honest and reasonable at every stage. Once again, Ninja Schnitzel. Go watch it. There is no reasonable, there is no honesty. And the only thing opening is her arms and legs. She appears to be an open book, at least since I've been involved. Well, good for you. Because she hasn't been open with anybody else. Or you just fell for it hook, line, and sinker. I am sure she would be willing to do a call provided we limit it to some reasonable amount of time. And yes, I know phone calls aren't as formal as a depot, So what? That really doesn't matter. Owens is an available witness. Blank is an available witness, so you really don't need to admit her depo testimony at trial, except for impeachment. I can see why Woodnick would want a depo over a phone call. Because, one, it is the truth to your best of your knowledge, could be considered perjury. It's official court business, and it is recorded. And there's usually an audio or video and a written transcript. So I can see why you would want that over a call, especially dealing with somebody like this. Because all they would have to do, and I know that Gregg would record it, but all they would have to do is lie and say, no, we didn't say that. My point is that even if a phone call doesn't give you admissible testimony, it still gives you helpful information you can use to decide your next steps. If you have questions and points, you are in the right direction to where you can confirm her answers. That would save the time and money of a depo. Plus, I think court reporters are overpaid anyway. Are you kidding me? I think court reporters probably need to be paid more. Because they have to shorthand write these things that they learned that somehow go into complete sentences of every single word said in a trial. Can you imagine typing up 8 hours a day of every word that's ever spoken for 8 hours in many, many different cases, or in one trial? You have to, sometimes make sure you can understand audio. You have to distinguish what is said even when people are talking over each other. So give me a break. Oh my God. That's so... I would never want to do any court reporting for him ever, since he thinks that I don't get paid enough. Or he thinks that I get paid too much. I would charge him double. So I just won't want to waste those costs. You gross, despicable human being. Think about this and let me know. Tone will remain down. Esquire. Ugh, he's just a gross pig. This is to Gregg Woodnick on April 8th, 2024. My comments back in blue. Disclosure, I should not have to keep asking for the missing information, which was required pursuant to Rule 49, the motion to compel. You stated several times in emails that you have the photo your client testified to taking on the day of the miscarriage, which has yet to be provided. It also appears you are now saying it occurred in November. Contrary to your client's testimony at deposition and in statements at the prior status conference, I assume you have the telemed doctor records and contact information so we can obtain the records with the photo from the source directly. Again, I should not have to keep asking about this as the court granted the motion to compel. See? Good faith basis in trying to get these things. DG's comments, there's obviously been a lot going on and I don't have unlimited hours in the day. I'm not holding anything back. I'm just trying to prioritize things. Tweeting should not be at the top of your priority list, and neither should blogging. Filing discovery should be number 1 on there right now. Has the judge actually signed the motion to compel order you submitted? If she did, I have not seen that. Assuming the order has been entered or is entering soon, I am obviously going to comply with it. But I still feel we have the other things to discuss that may relate to that order. Among other things, when I first got involved, I did not know, but obviously know now, that Corey Keith gave you a detailed disclosure statement on February 23, 2024. In your motion to compel, filed on March 11, 2024, you told the judge that blank had given you no disclosures at all for 8 months, and that she only recently provided minimal disclosures. Both things were totally and completely false. No, they weren't. She had to sign that in front of the judge. The judge knows that stuff wasn't false. He has P-stick results, and he has a picture of an appointment that apparently she never went to. In addition, because you refused to give me sufficient time to review this stuff, I did not know, but now understand that when you titled Motion to Compel on March 11, 2024, the only basis you had for the motion was Owens' general disclosure duties under Rule 49. In other words, this was not a situation where you served a specific request to produce or interrogatory that Owens failed to answer. The only basis for your motion was Rule 49. The judge said, turn over all this stuff. You are going to be signing these HIPAA release forms so that we can get all your medical records going back to 2020. Like, imagine that. Not even having a law degree and understanding what a motion to compel and the order that says you need to do this. I don't know why it's so complicated for him. But on February 21st, 2024, the court issued a minute entry order, which provided as follows: the parties shall complete initial disclosures no later than 45 days from today's date. Just turn the shit over. Why does this have to be like pulling teeth? Like, you have to turn over all your discovery. That's not new. You can be in law school and you know that you have to do that. Like, just turn it over. Stop trying to hide stuff. It's just ridiculous. But you want to wait till the last minute so that the experts don't actually have time to research the things. That's my guess of what's going on. He doesn't want Neumeister actually being able to review the data and all the photos and stuff and give it a report. So I think they're trying to put it off as long as possible. But I'm thinking if they don't do it soon, there is going to be sanctions for non-disclosure. Maybe to the attorney. 45 days from February 21st is April 6th. Based on this, it is clear you filed a motion to compel on March 11th and sought information that ordered no obligation until April 6th. I'm sorry, but there is no other way to say this. That is absolutely unbelievable misconduct. Never seen anything like it in all my years of practice. Okay. So look, I don't want to expand the argument here or make things more contentious, but this is one of the issues we need to talk about. I am very willing to be fair with you, but if you refuse to talk to me while simultaneously demanding that I comply with an order you obtained by lying to the court, well, that is not going to be productive conversation. Just turn it over. My God, this is so stupid. The bottom line is that I am willing to work with you and try and de-escalate this conflict. If you're interested in that, we have plenty to discuss. On the other hand, if you want to pound your chest and demand that I play by the rules when you have shown total disregard for the rules, that is not going to be productive. Because everybody needs to act like a child. So let's try to be productive here. That starts with talking And while I should not have to say this, it is absolutely 1,000% must involve complete and total candor. Candor towards me, candor towards the court, and every communication without exception. There needs to be candor from your client as well. Lunch. I appreciate the lunch invitation. I would consider free food after your client complies with her obligation. She has admitted to forging medical records from Smile, and our expert need the original, which she testified came from Planned Parenthood. As you have seen, Planned Parenthood indicated they have no records. That's how your client was there for an ultrasound on the day in question. Our experts, medical and Neumeister Tech, are waiting for the documents, and the motion to compel was granted. I will eat with you sushi after we have the information for the experts. Gigi comments, not a sushi fan, but I like Kona Grill. So if that's a fair compromise, let's do it. I actually tend not to eat much during the day. I'm getting fat and old. So the whole lunch thing was really a metaphor. Would rather meet you for a beer or some nachos. Do you shoot pool? Happy to meet you somewhere for a friendly game of pool. I am not a good golfer, but Top Golf would be okay as well. Your call on where, when, and what. Don't motion for lunch if you don't want lunch. It's not nice to dangle food in front of people. 3. Media. Any issues you have with Reality Steve Carbone or others who have covered the story after your client initiated this with the Sun is your issue. It has no bearing on the litigation. It is not something Clayton should be spending legal fees on. Gigi comments, no clue what you're talking about. I have not reached out to Reality Steve yet. Why is Clayton spending legal fees on media? I am not charging blank for anything I'm posting online. That is just me expressing my views about stuff. I don't charge clients for that. You freaking idiot. That's not what he is saying. Look, you need to get some sleep, sir. Something. Maybe get an energy drink from your client. Owens has reached out to the Sun and Reality Steve. Owens, not you. Oh my God. Experts. I understand Rule 702 and did not need the explanation. These very qualified experts are awaiting documents that you obstinately have, or confirm that the photos and supplemental medical records Owens specifically testified to having do not exist. At this rate, you might not have their something. Let's continue. Reports before 60 days, but that is only because your client has refused to provide the same. The disclosure you received provided a summary order of their anticipated testimony pursuant to Rule 49J. I will have more data for you as soon as Owen complies with her disclosure obligations, which again, we have been requesting for quite some time. Gingras comments. Again, if you would simply speak to me, I think you would instantly realize there are ways to simplify this dispute. In fact, in the spirit of trying to show what can happen when we communicate, let me share some information with you. How is this not communication? Y'all are apparently communicating. As I mentioned before, I have the photos you want to see. I understand you want to give them to your experts because you don't trust the truth the image dates. Gregg, that is not going to be a problem. You're going to love the image dates because the images are July 23rd, 2023. Still think you need an expert to debunk the dates? I would expect not. Yeah, because maybe she screenshot them on that date. We need the metadata. Have you never dealt with metadata before? Not that this matters, it absolutely matters. But I also have text messages between Owens and her sister dated July 23rd, 2023. Again, arguably helpful for you, but certainly not dispositive of anything. Just because she sent them to her sister on that day does not mean that she didn't spend days before trying to arts and crafts these things before getting her sister to be an alibi. I do have some telehealth info showing Owens seeking medical advice. I don't think this is helpful to either party, but I'm willing to disclose it. We've already read that because seeking is different. But here's the thing, I'm still on the fence about giving you the photos themselves unless you agree to not publicly disclose them prior to trial, if there is a trial. Well, the judge is going to make you disclose them. So it doesn't matter whether you're on the fence or not, you're going to have to give them over, plain, period, end of story. Given the incredible and appropriate circumstances which resulted in the MTC order being granted, I have still not decided if I want to fight that order further. It really just depends on how reasonable you are. More threats. Let's just threaten this. Threats. Everybody gets threats. If you are reasonable with me, I will be reasonable back. But it's hard to reach a conclusion about which side you're on when you won't speak to me. Okay, so what is all this? Is this a script? Is this a narrative? Did somebody write this? Are these not actually what people said? This is not communication? Because if this is not communication, what is it? Okay, and this says, regarding what is believed to be her first of 5 feigned pregnancies, petitioner was asked to comply with her disclosures of the same exhibit 4. Petitioner has willfully and wantonly failed to disclose information pursuant to Rule 49. After the status conference before this court, petitioner provided minimal disclosures. Minimal. It didn't say 0. It doesn't say none. It says minimal. So every time you say, Woodnick said that she provided none. No, he didn't. After evading any compliances with Rule 49 over 8 months. Now petitioner has testified to attending appointments and speaking with providers who only have access to records that are critical to support the miscarriage she allegedly had in September or October. Now it's in July or November. So we have 4 dates of possible miscarriage happened, or 4 months, but did not reveal to respondent or the court until her motion 4. All right, here's this. 24, petitioner's mom doc medical records. 25, petitioner's Barrow Concussion and Brain Injury Center Zyman visit summary consultation care document dated November 20th, 2023. Petitioner's Banner Health pregnancy confirmation, petitioner's positive pregnancy test results from Banner Health, and petitioner's Banner urgent care receipt. We've seen a lot of the Banner Health stuff. Petitioner's witness list. Petitioner will testify as to the factual basis underlying the issues in the proceeding as set forth in the pleadings and as disclosed in the proceedings on the matters for which she has personal knowledge and about which they are competent to testify. Respondent will testify as to the factual basis underlying the issues in the proceedings as set forth in the pleadings and as disclosed in these proceedings on matters for which he has personal knowledge of and about which they are competent to testify. Respectfully submitted 23rd day of February 2024, and that one was signed by Corey Keith. To Gregg Woodnick on Friday, April 5th, 2024, from Gingress. Gregg, one other quick follow-up, which I'd prefer to do in a call, but happy to leave this in an email for now. I just talked to blank about expert disclosure things. I've said this before, but I am usually very robotic and pretty strict when it comes to following procedural rules. That means if everyone follows the rules strictly, I am happy, and if people don't, I am not. You're never happy, sir. With respect to your experts, I am guessing you really aren't planning to call them. There just isn't enough time, and if there is any value in their testimony, which I can't tell due to the lack of details in the disclosure, that value seems like it would be minimal at best, plus the Daubert problem, etc. You know why he probably hasn't disclosed whether he's going to be using these experts or not? Is he doesn't have all the information to give to them for a report that he could use at trial to disclose. So the faster you hurry up and follow the motion to compel, the faster you can get a disclosure about experts. I'm guessing that's how that goes. But what do I know? With respects to your but blank and I are such reasonable people, we actually think maybe it would be okay if you really want to put one OBGY on the stand. Obviously, I would need, and am entitled to, a lot more disclosure about what this person plans to say and what their backgrounds are. I obviously need to know if the doc is married to Clayton's brother or whatever. Okay. But assuming no other red flags, I may actually be willing to agree that you can call an OBGYN because I'm guessing if that person is truly neutral and knowledgeable, they can offer some valuable information for us. Now, probably not, because your client has made up a bunch of things that aren't actually able to happen with the documents. So that is one of the issues I'd like to discuss, and this really shouldn't be too controversial. No, it shouldn't. No, none of this should be, but it is. Gregg, I appreciate the response to focus on matters at hand. We need to speak out. Speak about the status of disclosures. This is one of the items on the list. I understand a few days ago you disclosed the names of some experts, but basically nothing else. Obviously, the incredible scant details of these disclosures do not come close to what is required under Rule 49J. Did he say it did? And separately from that, I need to remind you that if you want to call an expert, you also have to separately meet Rule 702, admissibility standards, and the other requirements of Daubert. If you are not familiar with those requirements, attached is a brief where I explain them in some detail. I mean, at the end of the day, since you have a total of 1 hour trial time, I'm not really sure that I even care about this. When you deduct time for little opening and closing and the main witnesses, if you really want to call an expert and use your remaining time, maybe 1 to 2 minutes per person, to ask a few questions, I guess you can do that. Yeah, it's his case. He can do whatever he wants as long as it's in the confounds of the law. He doesn't need you to tell him what he can and cannot do. But thanks. But that's only if you disclose everything that is required, which you haven't done. It's not his first case. He will do what he needs to do to get what he needs to get done at trial. But yet you still don't disclose things yourself. So stop sitting here giving speeches about disclosing everything when you and your client have not disclosed everything. And only if you show compliance with Daubert and 702, also not yet done. Again, this is why we need to talk. If you leave alone for the rest of the day, but we need to talk on Monday. If I don't hear from you, I'm going to ask the court to order you to speak with me, so let's try to just work together collaboratively on this. And one last, read this comment, I would certainly accept that apology. Nobody's given you an apology, sir. 2 things. Yes, I absolutely do apologize if I was unprofessional or unpleasant. That was not my intent. Really? It seems like it's your intent. You're rude to everybody. that you come into contact with. Even if they have a difference of opinion, you still need to be nice, or at least civil. You need to respect the fact that Owens has severe, extreme concerns about your honesty and integrity. And nobody's worried about what Owens thinks of people, because she has no honesty or integrity in her body. At first, I did not share those concerns, but since I've learned about the case, I'm starting to see that Owens' concerns have merit. No, they don't. No, they don't. If you don't fully appreciate my concerns, I will say one last thing. I'm about to send a long email to Dave Neal. I assume he's working closely with you, but if not you, you should reach out to him and ask him for a copy of the messages. No, he doesn't need to do that. And Dave Neal is not working with Woodnick. But nice try. Since you don't know me that well, the email may provide some helpful context. That's the main reason I'm sending to him. If you want Woodnick to know the contents, then you need to share it with Woodnick, not Dave Neal. And I will tell you the same thing I told Dave. There was a good reason to make some public comments to explain Owens' position, but that is now done. I don't plan on speaking much more about the case in public, unless it is necessary to respond to false information someone else has published. Hope that makes sense. Nobody's posting false information except for your own client. So talk to her, because that's where we get our information, is from her directly and from courts. We're not here making lies up with nothing to back anything up. We're giving the information out, and they can see things with their own eyes, and if they don't agree, then they are free to disagree. But that just hasn't been the case. The only people that disagree are Owens and her family and you right now. Everybody else sees the light of day. Woodnick states on Friday, April 5th, 2024, David, I have disclosed medical experts who would like to see photographs, Planned Parenthood and telemed records about alleged miscarriages, as it may impact their efforts. Brian Neumeister is prepared to review the data as well. Please provide the disclosure, and then we can discuss resolution options. I appreciate that you say you will tone down things, but it is contrary to your recent blog post and continued activity on Twitter. I respectfully disagree with you legally, but that is what the courts are for, not for the zoo-like atmosphere online. All right, guys, we're in a zoo. Are we the monkeys? With regard to the YouTube and podcast crowd, remember that was actually created last year when Owens was posting and arguing with Redditors and sending ostensibly altered data to Steve Carbone, which is Reality Steve, and others. As for lunch, I enjoy food in my 20 years of practice. Beer, not now. Just ignore the people online. Because Woodnick hasn't responded, you don't need to respond. Do it in the courts. Friday, April 5th. Gregg, I just tried calling your office but got no answer. I think it's been over a week since we have spoken by phone. So he has spoke to you. There are tons of issues that we need to talk about, and email just isn't cutting it. We need to talk soon. Since you were about the same age, maybe you saw this back when it happened, but if you didn't see this, I politely ask you to read Judge Gaines' famous order gaining plaintiff's motion to compel acceptance of a lunch invitation attached. Right now, we don't need to meet for lunch, although I'm happy to do that. Right now, all I'm asking is for you to have the courtesy of accepting my calls so we can talk about the case. Tone will be calm, friendly, and professional. The fact that you have to say that because nobody believes you is ridiculous. Like, if you were acting professional, you wouldn't have to state that you're going to act this way. If you won't agree to talk, I guess I will ask Judge Matta to order you to accept an invitation to lunch. Such a crybaby. Then the rules on pending motions. The court has reviewed the pending motions. 2 will be granted, the others will be deferred. Plaintiff's motion to compel acceptance of lunch invitation. The court has rarely seen a motion. Okay, that's something we read earlier. This is not the Echard case. This is that other case that was mentioned prior, like something v. Miller or something like that, I believe. I have to keep removing things that are duplicates because this thing would have been a lot shorter if there wasn't so many duplicates. So he's got a picture of a post. New motion filed yesterday, 4/8/24 in Owens v. Echard. I'll probably post a short blog update later this morning at gingrislaw.com. Motions. And then he has a little picture of his motion to compel lunch and for all alternate relief, which we read in a previous video. Here is blog posting. We have read that in the blog post video as well. So for now, onward we march, absent a last-minute settlement, which is probably the most likely outcome. As I said, that is not the most likely outcome, unless your client apologizes and admits to lying and clears Clayton's name, probably both Gregg's names. Probably be nice if you did it to the 2014 person and Michael Maraschini, but doubt she's willing to do all that. We have a trial in June, and the judge will decide who is lying, who is telling the truth. The only issue not up for debate is the bullshit motion for sanctions that Clayton filed in January, and which he has now withdrawn, and that is a good thing. P.S. As I get more up to speed with this case, I'm really starting to lose patience with the small but vocal handful of people out there who are milking this case for personal financial gain. I am not one of them, since I make $0 from writing this stuff. You, the guilty and the dirty, know who you are. These people, not naming names, are generally blogging or hosting YouTube videos every day to talk about the videos every day to talk about the case. Okay, I guess that wasn't cut out. Okay. But they are not really talking about the case, not even close. They don't explain all the facts. They don't give both sides of the story like any real journalist would. We're reporting things from that Owens has put out there. So how is that not reporting both sides? We're giving our opinion on Laura's documents. This is all stuff that Laura put out there for us. So how is that not reporting sides of the story? We're showing her evidence. We're saying we don't believe it. She won't go and talk to anybody, even though everybody has said if she wants to go and be on any of these podcasts or YouTubes, they would love to hear her side of the story. But we're also trying to get her side of the story from court documents and the court hearings. So don't say that we're not. I know I'm not grouped in with these people because I'm not in that big group, but still, not everybody reporting on this is getting financial gain out of it. At the end of the day, they don't give a shit about this case, and they don't give a shit about the people involved or the truth. They are nothing but mosquitoes sucking their meager livings out of the First Amendment I have fought so hard to protect. These human leeches are selling half-truths and twisting shit way out of perspective in order to increase drama, so much drama, and thereby get a few pennies of Google AdSense revenue and a few super chat bucks to pay for breadsticks. Do you think Emily D. Baker makes breadstick money on her AdSense and her super chats? Because that's funny. She's not reporting on this case, but you think that YouTube isn't a way to make a bunch of money? I'm not saying anybody is in this case. I don't know how much people are making on it, but yeah, measly pennies. It honestly makes me puke. F these 6 selfish, lying assholes. Should I clarify how I feel? These vile scum, I mean people, are not helping anything. They're human cockroaches spreading feces on the floor and then spinning the fact to make them more dramatic than they really are in the hopes that this will drive traffic and increase their revenue for their sad, pathetic lives. How are they making it more dramatic? Like the stuff is in black and white. I am putting it up in black and white. I am putting it up there. I'm trying to blow up the stuff so people can see it clearly themselves. I put the links to where they can find this stuff so that they can go look at it for themselves as well. So, not spinning facts, we're just reading the stuff. One day, these trash humans will wake up and realize that lying for money is not a good way to live. None of us are lying for money. None of us are lying in this particular case. The only one lying in this case is your client. Or maybe they will never see their sins. Either way, I look forward to reading their obituaries briefly before throwing them in the trash where they belong. Some could say the same about you. Like, why do you even need to talk this way about people? So what? They're talking about your client. Who cares? They have the right to do that. But, and you even say in a lot of your blog posts, I can see why people would think this. I don't blame people for thinking this about my client. Well, then what is your problem with these people? Megan Fox, Tug, Legal Vices, Dave Neal, Reality Steve, anybody else talking about this case. They have the right to talk about it. They can make their own opinions based on what they see. And so can everybody else that has followed this case. You need to throw your attitude in the garbage where it belongs. More posts. Thanks for the $1. When I go to the casino tonight, I'll put it on the roulette wheel and let fortune decide my fate. Also, I don't plan to make further comments, public comments for now. The process was helpful, but not very productive. Moving on to other tasks. I doubt that it wasn't productive. Because it seems like all the things you spun to try to be your argument was debunked, and you saw why that can't be your argument. Because there are holes in it. There are too many lies to make that the actual story. So you needed to keep trying. And then it says, I am commenting because there is a huge amount of misinformation being spread unfairly about Owens. The purveyors of these lies will likely be sued in the near future. For now, I'm trying to correct the record and help people understand the law. I'll blog about that ASAP. What are you going to sue them for? Because it can't be for defamation. One, because there is no malice in what we're doing. And when we see something and that it can be construed this way, so we think that it is the truth, because nothing has told us it's not yet, then it's not defamation. We have to knowingly know that what we're saying and putting out here, which is basically reading court documents and putting information on the internet, that those are lies. And to our true and correct belief, we think that they're the truth. Reading court documents can't get you sued. You're just reading public information. So I don't really know what she's going to be suing for. Just look at Alex Jones. He spread lies about parents who lost their kids in a school shooting. This has nothing to do with that. They are nowhere near the same thing. Nowhere near. He was sued, couldn't prove his lies were true, and the jury ordered him to pay $1.5 billion. Anyone who thinks it's funny to spread lies better own a tent and a sleeping bag. He couldn't prove that he didn't know what he was saying was false. When you ask any of us, any of the Pond Scum posse, whether they can prove that what they're putting out there is true, they're not going to be ordered to pay a dime. And when this court case is over, and hopefully shows that she is a liar, you definitely won't be able to sue. But she's not in this for the money, right? And what makes you think you so confident you know the truth? Were you there when Clayton and Owens hooked up? Have you seen all her medical records? I have, and trust me, the people who have accused Owens of lying are probably going to end up sued for defamation. Not talking about you. See, defamation. No, they won't. Because while we're saying those things, we are reporting based on the medical records we have seen. Or the lack of medical records we have seen. Have not seen, basically. So, no. Now, if something comes out in the medical records that prove Owens to be right, and we don't report that, that would be lying. But right now, we're going off of what we know. And what we know right now is she is lying. And nothing proves that she hasn't been lying. So there will be no defamation suits that Owens is going to win. Because y'all cannot prove that at the time of saying all this, that we knew what we were saying was a lie. Because like you said, we don't have all the information. So once we have all the information, we can still give our opinion on whether we think she's lying or not. Because we don't think Owens is credible. Credibility is a big thing. Nah, they can refile any time. This guy won't be around long anyway. Judge is going to chew him out and spit him out. That is what somebody had posted. Gringa says, here for the long haul. Don't believe me? Let's bet. I'll bet you 1,000 my own money that I will be here through the end of this case. Want to take that bet? Message me and we will set up escrow for the wager. I won't hold my breath. Who goes betting people on Twitter that they don't know? Is that a yes? Put your money where your mouth is. We both know you won't. Enjoy troll life. #sad. We're just basing things off of what the other attorneys have done. Because they ethically, once they found out the truth, removed themselves off the case. They said, you're a liar. I can't say this stuff to the court. So therefore, I have to withdraw. And if you don't withdraw, knowing that she's a liar, and you sit here and put falsehoods to the court, then you're wrong. You could lose your bar license for that. And then the person says, don't need to, so he doesn't need to put his money where his mouth is. He can just watch you fail and laugh, basically, because that's all we've been doing. He's been very funny out here, and it's just failing and us laughing. Hang on. Several people posted shame on you for posting someone's name. I have no clue who they're talking about. Now you are saying you want nothing confidential. Okay, which is it? All confidential or nothing? Again, Owens asked for confidentiality and Clayton said no. You obviously don't know the case when writing this post. Here's him replying to Megan Fox. And yes, of course I read my own emails. I have no idea who blank is. No idea why he would need to be shielded from public view. Clayton's lawyer should have told me that, but never did. If this crazy talk continues hard, blocks will follow. Seriously, stop. You're the one who asked for this. For like the 99th millionth time, asked for a protective order. She asked the court to say that certain stuff should be kept private. Clayton opposed this. He wanted nothing to be private, and the court agreed. If you don't like that, tell Clayton to change his view. Her not wanting her name out there when this all started has nothing to do with Clayton. It has everything to do with your client stating she's the anonymous woman. You don't know this case. And then here's his don't like my bio, ask for details. I'm the Conor McGregor of litigation. Done tons of family law cases. I don't list those because they're boring. So only the exciting cases. Sounds like your family law cases you don't even care about, which I'm sure your clients would love to know. FYI, Clayton's lawyer has handled 2 federal cases. High-profile cases go to federal court. Not always. Johnny Depp's case did not go to federal court. I think Alex Jones' case was a high-profile case. Didn't go to federal court. O.J. Simpson's trial. Was it federal? Pretty sure it was state. Because any case that is televised obviously is not federal court. Because federal court doesn't allow you to record. Gwyneth Paltrow was not a federal case. So what do you mean by high profile? There's a bunch of high profile murder cases out there. They're not in federal court. Anyways, me, 79 federal cases and counting. Well, good for you. Nobody cares if you've done federal cases or not. This is not a federal case. This is a family law case. But those are boring, right? You've said yourself you are trying to get up to speed with this case. There are people posting replies to you that know this case inside and out. Every court document, every televised court hearing, every article Owens has written about this. Why do you assume they are lying? And put all of the noise aside. Blank had multiple positive pregnancy tests before she filed this case. Not one, not 2, multiple positives, including one purchased by Clayton and taken directly in front of him, which was positive. What else really matters? A lot of things matter, because a pee stick isn't confirmed pregnancy. It's a possible that you are pregnant, that you need to go to the doctor for further confirmation. Keep peeing on sticks doesn't prove anything. And she still went to the bathroom to take the pregnancy test. She didn't pee in front of him, like literally in front of him. The only remaining issue in the case right now is this. Did blank lie about being pregnant? Yes, she did. Yes, I'm still new to the case, but the evidence on the point appears to be 1,000% clear. She took a pregnancy test that Clayton bought in front of him. How is that not conclusive? In front of means a bunch of different things to apparently other people. In front of means like they are in front of you. Like she peed on the stick in front of him. No, she went to the bathroom. I'm not assuming they are lying. That isn't how this works. Clayton has a duty to disclose admissible evidence to me through his lawyer. I get to look at that evidence and determine what that means. Views of strangers on X is not admissible evidence. No, but we're telling you where the evidence is that you can find, where all the lies are. And if there's not admissible evidence, then why are you even talking on Twitter? It's pretty simple. She has already admitted to doctoring ultrasound. She never saw an OBGYN who performed an ultrasound. That is the only way to confirm twins. The woman lawyer was the fastest to piece out because any woman worth her salt can see right through this. The woman lawyer took a job in another state. Her leaving had nothing to do with Owens. And blank has testified she did have an ultrasound. She admitted changing the name of the place where it was done, bad idea, but she stands by her story. So what if it was twins or not? Because she's lying. It says, a woman can file a paternity case with 0 positive tests. She can file the case just because she missed a period. She can file the case just because she thinks she might be pregnant. Even if she ends up not being pregnant, it's not illegal to ask the courts to help verify paternity. And if you feel a positive lab test doesn't prove anything, that's fine. That is your opinion. I respect that. But legally, you are wrong. Medical tests are admissible proof, bearing in mind there is no legal requirement that Owens ever test positive before going to court. Nobody said before going to court. It's in November that she said she was pregnant. She said in November she was still pregnant. So when she doesn't have proof of pregnancy for November, when she said she was pregnant, that's where it becomes a problem. And there is a legal requirement that she needs to prove that. One step at a time, blank went to urgent care. She asked for a pregnancy test. They took a sample, sent it to the lab. The result, positive. She went to urgent care in Gillespie's case. I don't think she went in this case. No, she did go to urgent care because that's what Banner Health was. My mistake. Let me explain as clearly as I can. This case is not about offering 1,000% confirmed proof she was pregnant. That is not an issue under the law. The only question is, did she have some reason to think she might be pregnant? That's it. That is it. If so, we win. No. Because you're going to have to explain why you lied in November thinking you were still pregnant if she miscarried fetal sacs in July before she filed this case. Bottom line, Clayton cults hate Owens because you do not understand what is going on here. That mistake is making you see the case incorrectly. I am trying to explain and clarify so you understand, but people are not listening. That's fine. I will keep moving forward. Owens must think she's pregnant 24/7. Because if we go on what Owens believes, that would be one thing. If that was all we were looking at. And if that was all that was at issue here, is that when she filed this, she thought she was, but that's not what it is. It's the fact that even if that was the case, let's giving her the benefit of the doubt, she thought she was. As soon as she knew she wasn't and realized she wasn't, but kept lying, that's where the problem is. That's where all of us have a big issue. Because if she would have just said, hey, I thought I was, here's the proof that, shows the reason I thought I was, and now I'm not. But no, she had a growing belly that looks to be fake. She's doctored sonogram photos. She has lied about medical professionals, and so on. So I think we have a clear understanding. And maybe if that's all it is for the court case, then that's all it is. But we have the right to be pissed that she continued with this case and her lies after she realized she wasn't pregnant. But we also have the right to question her credibility, because there are 4 to 5 men out there that have had to do the same exact thing. Find out what makes this woman's tests positive. Because this woman has a magical power of being able to test positive for pregnancy. She could really go into business just selling positive pregnancy tests if she wanted to. Doesn't matter if she never had an ultrasound. Doesn't matter if she faked an ultrasound. Doesn't matter if she never sought OB care. Doesn't matter if it was twins. Doesn't matter if they weren't Claytons. At some point, you'll catch on to know how this works, and you're not there yet. What other legal arguments are there? Genuine question. Can you give me the rules you'll be mentioning so I can look them up? It does matter if they were Claytons, because that is a part of it. She said she believes them to be Claytons because she's tight as all get out, which we didn't need to know. She's not had sex with anybody else. So I think it does matter if they're Claytons or not Claytons. And she should know if they were or they weren't. Or she lied once again. And I think the court would have a huge problem if she faked an ultrasound. She said she had twins and didn't. I think all of that matters. And the fact that you don't think that that matters to the judge, I cannot even comprehend that. Tell that to the judge and see what the judge has to say. That it doesn't matter if any of this is real. Because I don't think the judge will agree with you. Owens is also probably going to file 1 or more motions for sanctions under a bunch of different rules/laws. Don't ask for the details. That will come when the motions are filed if needed. I'm intrigued by what sanctions will be requesting. If he does not withdraw the motion, the rule gives him 10 business days, then we will file a motion for sanctions. Well, we knew that's already been taken care of, so nobody cares about that. I'd be interested to hear what piqued your interest in posting updates about this particular case versus other cases you take. Main thing is because one party is aggressively making a public statement about this case, and blank feels her story is being drowned out by misinformation. That is a problem that needs to be addressed. So I've decided to post some info to try and clear the air. More to come soon. I'm sure you will, just as her revolving door of previous lawyers got there. Good luck. In this case, one lawyer left to take a new job, and the second guy left after Clayton's lawyer threatened him. Poor guy was young and not ready for the battle. No, that is not what happened. I am ready for the battle. I'm not going anywhere. What about her attorneys in the Gregg Gillespie case? What about all them? I know it's a different case, but these are all combined. This is under one umbrella. Because so much has been brought into this case. Because at first it was just about Echards. And then now we're having the judge go back all the way to 2014 with all the other men because it's a pattern of hers. Explain this pattern. Can you debunk all her patterns? With evidence, not just by her word, because nobody believes her word. We believe evidence, not her mouth. Attempt to get someone to sign a relationship contract 2 weeks after they allegedly argue is insane. If that is what happened, you may have a point, or maybe you only know like 3% of the facts, and forming this strong of an opinion based on 3% of facts is honestly effing stupid. We get to form an opinion based off of what we know thus far. That opinion can change with the more and more information that comes out. So telling people that they are stupid for opinions for all that they have is effing stupid. Just because you have more information than we do, your point of view and your opinion is based on something more than what we have right now. And if you think we're honestly effing stupid once we have all that you have, then go ahead. Say whatever you want to say. But I just think you're honestly effing stupid. Like, I just cannot imagine anybody ever wanting to hire you. If you can show me how blank lied, I would drop her as a client instantly. If you mean what you say, you'd be open to helping me understand the truth. That is all I ask. If you turn your back on my request, what does that say about your true motives? Everybody tried to give him things to help him understand the truth. I don't think any of us turned our backs. And if it looks like people have turned their backs, it's probably because they blocked him. Or he blocked them. But you're not seeing any of that. She had a DNA test done more than once, and all results said little to no fetal DNA. Doesn't matter when she miscarried, as fetal DNA lives in mom's blood for months and sometimes years after a miscarriage or delivery. This is definitive proof there was never pregnancy. Great analysis. Just one thing. Do you have a pic of the time machine used on 8/1/23 to go forward in time to 10/15/23 to see these test numbers, then travel back to August 1st, 23, where she proceeded to maliciously file for paternity, knowing that what the future held? Please send pics. She knew way before this. Way before all this. If she miscarried in July, she knew. So we went back to the future and saw she maliciously filed, if the July is the truth. That is all of the response to the motion for lunch. Woodnick put in all of the stuff and all of Gingras running his mouth and saying horrible things, and really, to me, just showing his true colors. And this quote of the day is for Gingras once again. We don't always have to agree with one another, but it's important that we learn to respect each other. You need to learn to respect people. Just because they don't agree with you and their view on something is different doesn't mean that they're stupid. Doesn't mean that they're poor or uneducated. It doesn't mean that they need to die or be homeless. It is okay to disagree with people. You don't have to hate somebody just because you don't agree on everything. Uniqueness and different points of view is what makes this world interesting. I like hearing different perspectives. I want to be able to argue both sides and put the holes in each story, saying, you know what, they have this, but this might need to be proved. So everybody, just be respectful out there. You know, just because somebody believes in different things, still remain their friend. Don't block them. Don't be hateful to them. We all need to remember to do that. But that is it for me. If you want to stay tuned for more videos in the future, please hit that like button or the subscribe button and turn your notification bells on. Like this video on your way out if you haven't already, and I will see you in the next one. Bye.
Loud little ducky coming through, speaking truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose the hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. I'm sparking revolution. It's a truth-telling tale.